Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We're a specialist litigation and commercial law firm based in London. This video is for anyone considering taking out legal proceedings, issuing a court case. There's a maxim often heard, which is start with the end in mind. And if you're going to issue a court case, the successful end is going to be a judgment. Now, a judgment is what the court will give you if you successfully pursue your case. Now, it could be for an injunction, it could be to change a boundary, but it's most likely going to be about money. So the court likes to solve problems with awards of damages and cash. So if you successfully pursue your case, you will end up with a court judgment saying that the other side must pay you a certain amount of money. Now, if you're going to start with the end in mind, the first question that you have to ask yourself is, can the other person actually pay that amount of money if you're successful? If you get a judgment for £500,000, wow, brilliant, but does the other side actually have £500,000 to pay you? The thing about a court judgment is it is a very powerful piece of paper, but it is just a piece of paper. So you need to be clear from the very beginning about whether or not your opponent can pay the amount that you're seeking from them. If they can, then great. Let's carry on with the proceedings. Let's get the judgment. As I say, a court judgment is a very powerful piece of paper. What kind of powers does it give to you? Well, if you've got a judgment that says you must be paid £500,000, then you can do a lot of things with that judgment. The first one is that you can register a charge against any real property or any shares owned by the defendant, the losing party. Now, if you've got a property and you register the charge against that property, that means that they can't sell that house or that office block without paying you first. If they're not going to sell it at any point in the future, you can apply to a court and say, we want an order for sale to compel them to sell their property so that you get paid. Really very useful. You can do the same with shares as well. So if this is a business dispute between you, say, and a fellow director shareholder, if you get a judgment against them on your behalf, then you can register that judgment against their shares and apply to the court for those shares to be sold. But you can also do other things with a judgment. You can apply to the court for what's called a third-party debt order. Third-party debt order, once granted, is served on the banks. If you have the details of a bank account of your opponent, then you can send off your third-party debt order to their bank, and that account will be frozen until the money is paid to you. So again, very useful. Of course, the other thing that you can do is you can, to use the phrase, send round the bailiffs. You can enforce your judgment against any goods owned by your opponent. If registering against property isn't working for you, if freezing bank accounts isn't working for you, or if they've got no goods to enforce against, then you could apply for a bankruptcy or winding up petition. That means that all of their affairs are dealt with by a trustee in bankruptcy or by a liquidator, and their job is to get in all their assets and pay that money to you. But I have to say that if you're getting to the point where you're going to put a company into liquidation or put somebody into bankruptcy, think about it very carefully, because the chances of you getting paid in that case are pretty small. Finally, there's another tool when it comes to enforcement, and that is called an oral examination. And that's where you force your opponent, the losing party who owes you the money, you can force them to go to court on pain of a prison sentence to tell the court about their assets, to give the court and you details of their bank accounts. And that way you can then use that information to use the other enforcement methods. So judgments, they are just pieces of paper, but they're very powerful pieces of paper. As I say, your first decision has to be, does the other party have the funds to pay you? If so, then let's proceed with the case, let's get the judgment, and then use that judgment to enforce your debt and get your money. My favourite enforcement story, though, is about a client of mine. It was a case of unpaid professional fees. My client was an accountant, and we had to go all the way to trial to pursue this case, and we won at trial, and we got full payment of our client's fees and full payment of his legal costs as well. So it amounted to a considerable sum. At the end of the trial, however, before we got to the judgment, my client went to his opponent and he said, "I don't know how we got here, but I think one of us will be pretty unhappy tomorrow." And they agreed and they shook hands. Now, we won that case and we were paid within 7 days of getting the judgment. And I think it's because my client went and shook his opponent's hand. If you've not shaken your opponent's hand at the end of a trial and there isn't that kind of goodwill, then if you get a judgment in your favour, what you're going to have to do is undertake the enforcement proceedings that we've just spoken about. So if you've got a judgment that you want to enforce, or you're just beginning legal proceedings and you're considering bringing legal proceedings, we'd love to hear from you. Please get in touch. Go to the website, press the book a meeting button. That gives you 30 minutes of our time, absolutely free of charge. Or you could do any of those things, or you could leave a message or a question in the space below this video. Thanks very much.